There are matters, however, that counsel want to have resolved dealing with various issues that relate to further testimony in this matter, and the court will discuss those matters with counsel. One of the matters to discuss relates to the people's motion pursuant to Evidence Code Section 1016 to obtain the therapeutic or psychological records prepared by Dr. Oziel of sessions conducted with the defendants, other than the 2 sessions that were ruled non-privileged by the California Supreme Court. The people's position is that now the defendants have testified and that the defendants have put before the trier of fact not just their testimony, but that of their expert witnesses, that the defendants, by doing so, have placed their mental state at issue, thereby constituting a waiver of any patient-therapist privilege that otherwise existed and that the Supreme Court ruled existed in this matter. This issue has been briefed, and the briefs have been presented to the court in anticipation of the matter coming to a head by reason of the testimony of the defendants and the experts, all of which has occurred. And related to these matters is a secondary issue that only comes into play if the court finds the people's position has merit, that there is a waiver, has been a waiver under Section 1016 of the Evidence Code relating to the patient-therapist privilege. And the related matter is a claim by the defendants of an attorney-client privilege relating to specifically the session between Dr. Oziel and the defendants of December 11, 1989, which was tape recorded, that particular session, tape recorded and preserved, and the defense has asserted attorney-client privilege in relationship to that particular session as well. Are the parties then ready to proceed in argument to supplement your written materials in relationship to the Evidence Code Section 1016 issue? All right, since the people are the moving party, we'll hear from you.
Your Honor, as to the issue of the psychotherapist patient privilege, I think it's clear from the cases cited by the people that by tendering the particular defense that the defendants have not only tendered but now offered, that they have in fact waived the psychotherapeutic patient privilege. And I don't have anything to add to that. I think that there could not be a more fully developed mental state case than this one. We have testimony about their abuse from ages 0 to the present time. And so because of that, I think that the psychotherapeutic patient privilege should not apply. And as to, and it would be our position that it applies not only to any notes from Dr. Oziel, but any other therapeutic sessions these defendants have had. I don't know what the nature of the relationship is between Dr. Bakery and Eric Menendez, but if he was in fact treating him versus preparing him for litigation, then those notes of treatment should also be made available to prosecution. As to the attorney-client privilege, our position is fairly straightforward. In the summer of 1990, in essentially the absence of the prosecution, extensive hearings were held in order to determine what exactly happened between Dr. Oziel and the defendants in this case. And pursuant to that, certain findings of fact were made by Judge Albrecht in Santa Monica. And the finding of fact with which we are most concerned is the finding of fact, which is in our version is fact number 9, is that the sessions were intended by the parties to be for the purpose of therapy. It is also apparent from the findings of fact, which I believe the people's copy is redacted, that Dr. Oziel did consult with Mr. Chayla prior to the December 11th session and that there were certain disclosures made to Mr. Shayla before that session began. So it's apparent from these findings of fact that the presence of Mr. Shayla and the issues relating to his representation of the defendants at least was discussed, although in the absence of the prosecution. And we are aware of the fact that there may have been further in-camera testimony from Mr. Shayla in this courtroom regarding this particular privilege. But the point is this: the defendants had the ability in front of Judge Albrecht to explore all the different claims of privileges. Factually, we know that Judge Albrecht was made aware of Mr. Shayla's introduction to the case in the summer of 1990. The Court of Appeals in this case sustained Judge Albrecht's findings of fact as to the first two therapeutic sessions and overruled Judge Albrecht's findings of fact and instead substituted their own findings of fact. Interestingly, the Supreme Court struck down the Court of Appeals findings of fact and reinstated or refound the findings of fact by Judge Albrecht. That is, that those sessions were intended for the purpose of therapy. The Supreme Court of California found that those findings of fact as to the December 11th session, and this is at page 454 of Menendez versus Superior Court, the Supreme Court found that this particular finding of fact, that it was for therapy, was amply supported by the evidence, and therefore the court threw out the interpretation and reinstated the trier of facts interpretation. We therefore have a ruling from the Supreme Court that these sessions were for the purpose of therapy. If they're for the purpose of therapy, and if the defendants have put their mental state at issue, then those particular sessions should be revealed to the prosecution if the court finds that 1016 has been met. It would be the people's argument, and I think it was stated in our response to the defense answer to our first pleading, that manipulating the facts in order to address a particular situation is at best disingenuous, and that when the defendants were permitted to be real parties in interest by Judge Albrecht over the people's objection, when they obviously presented evidence about conversations with Mr. Shayla before the December 11th session, that these matters and these factual findings were tailored by the defense to get the result desired. And that to now come in and say that that finding of fact should be overturned by this court when it was pursued by the defense into the Supreme Court, and they are the petitioners who sought appellate review of the appellate court's findings of fact, that in fact would be a subversion of the system, because what is important is that these findings of fact were found by Judge Albrecht, overturned in part by the Court of Appeals, and reinstated with substantial evidence being found by the Supreme Court. And so those are the findings of fact of this case. And to now come in and say, well, not really, that there's other issues that should have been addressed or should now be addressed, would be to ignore the work that was done and the appellate pursuit that took the better part of 2 or 3 years. And so it's our position that having now sought these findings of fact, the defendants are essentially compelled to be bound by them.
Your response from the defense.
I think it's important because of the way people argue this matter, that the court focus on the language of 1016 because constantly in the papers and also here in court and also as the court characterized it, it was characterized as if the defendants had put their mental state in issue, 1016 applies. And 1016 says there is no privilege under this article as to communication relevant to an issue concerning the mental or emotional condition of the patient if such issue has been tendered by the patient. And first of all, it's our position that there is a difference, a legal difference between mental state and a mental or emotional condition. And
So what's the difference?
Well, I think mental state is a much more broader concept than mental or emotional condition. I think the court can see that quite clearly if the court looks at the mental state exception to the hearsay rule. 1251 says, evidence of a statement of the declarant's state of mind, emotion, or physical sensation, including a statement of intent, plan, motive, design, mental feeling, pain, or bodily health at a time prior to the statement is not made inadmissible, and then it goes on to discuss it.
Well, I agree. Let me interrupt you. I
Sure.
agree that the argument here should be confined to the language of Section 1016 and any case law that interprets it. And I agree with you that the statute does refer to mental or emotional condition rather than mental state.
And the further point I was trying to make is if the legislature wanted to have this section apply as broadly as the people wanted to apply here, that is, anytime the defendant puts into issue mental state in the broad sense, and in the sense used in 1251, that this section applies. They certainly could have done so and did do it in other sections where they describe mental state or state of mind in a much broader context, in much broader terms than they do in 1016. So it's our position that mental or emotional condition is a narrower concept. It's a subset of state of mind, but it does not encompass a situation where state of mind in some general sense is an issue.
Okay, I agree with that. Clearly, it is a more narrow concept, but let's focus on what has been produced by the defense in this case as to whether it constitutes evidence of a mental and emotional condition.
And that was the second point I was going to get to, which is it's our position that in trying to find out what the legislature meant when they talked about mental or emotional condition, when they talk in the comments about this specific provision, they talk about diminished capacity or insanity as the two situations in the commentary to the evidence code for this section, which is mental or emotional condition being tendered by the defendant. And other than those two situations, it's our position that the section does not apply. And one of the cases we cited to the court was Carlton versus Superior Court, which focuses not on the language mental or emotional condition, but on the language the issue has been tendered by the patient. And it's our position that the people tendered mental state in this case. They're the ones that brought this action in which they put into issue the defendant's mental state of whether they had the presence of malice of forethought or not. And the defense, in their defense, is responding to that allegation and negating malice of forethought. And the Carlton case reviews a legislative history of 1016 or the analog in the physician-patient privilege and points out that this section was not intended to apply to a situation where the defendant is responding to the plaintiff in a civil context, putting into state mental issue. And at 290 of that case, the Carlton court points out that the original version of 1016 and of 996, which is the physician-patient analog to this provision, provided that in an action, there is no privilege in an action in which the condition of the patient is an element or factor of the claim or defense of the patient.
How does that relate to the diminished capacity comment?
Well, I think it relates because I think the legislature recognizes that except in those two situations, this section does not apply. In other words, the commentary indicates that diminished capacity and insanity are two situations that they have carved out for application of this section.
Well, but how does that relate to your argument that if the prosecution puts the mental state in issue, therefore 1016 wouldn't apply?
It relates in the sense that in those two situations, obviously the defendant is negating malice of forethought and is responding in a defensive way in the same way that we are in this case. But those are the only two situations where this section would be applicable because in general, the drafters of the evidence code rejected the idea, according to the Carlton court, that responding in a defensive way to the other party putting into state your mental issue is the subject of this exception.
How does the defense posture in this case differ from diminished capacity by analogy for the purposes of your interpretation of Section 1016?
Because our defense does not.
I'm not saying it is diminished capacity. I'm just saying that as far as your argument is concerned, you indicate there is an exception to 1016, and that exception is, or one of the exceptions is diminished capacity, yet the purpose of 1016 is to protect the claimant of the privilege if the claimant is not putting in issue the mental state, but the prosecution is, or the plaintiff is, or the party who does not hold the privilege. And my question is this not analogous to a diminished capacity situation where the prosecution is alleging that the crime was committed with malice aforethought, premeditation, and deliberation, and the defense responds by offering evidence such as what you've done here, which is analogous to a diminished capacity?
Well, it's our position it's not analogous because the insanity diminished capacity defenses depend upon the presence of a diagnosis in general. And it's typically the diminished capacity defense is based on a psychiatrist saying the defendant had a mental disorder or an emotional disorder. And based on that disorder, he did not have the capacity or she did not have the capacity to form the required mental state. And the idea of 1016, in our view, is that it's unfair of the defendant to put into issue a diagnosis and then rest on the privilege, which could contain evidence contradicting that diagnosis. And it's our position that this case is different because we have not offered, and in fact, the experts have been very explicit that they are not diagnosing mental or emotional disorders in this case. They were asked whether they had a diagnosis, and they indicated they did not. The state of mind that's an issue here is fear at the time of the crime. And legally, fear, unreasonable or reasonable fear that you're going to be killed is negating malice. But the presence of that fear does not depend, in this case, on the presence or absence of a mental or emotional disorder. And that typically is a situation in diminished capacity or insanity that is not present in this case.
Does the comment to Section 1016 talk about mental defect or disorder, or it just uses two examples by way of example, not guilty by reason of insanity and diminished capacity?
Well, it says, although the psychotherapist patient privilege applies in a criminal proceeding, the privilege is not available to a defendant who puts his mental or emotional condition in issue, as, for example, by a plea of insanity or a claim of diminished responsibility.
All right. Does that comment then limit the exception to just those two claims by a defendant?
No.
Just by example, it doesn't say exclusive.
That's correct. But then if you look at the legislative history referred to in Carlton, the court says it is significant here that in submitting its recommendations for legislation on this subject, the Law Revision Commission stated that there is no logical basis in support of the defense of the patient portion of this rule, and that the protection of the privilege should not be withheld from the person who is the unwilling party to the action. Therefore, it is recommended that or defense of the patient be stricken from the rule. And the court says it is apparent from the adoption of Section 996 in its present form that the legislature followed this recommendation. So that legislative history can't be squared with the people's position that this section applies anytime the defendant is attempting to negate malice.
Well, I'm not making any or dealing with any broad-based approach to change the language of Section 1016. What we're dealing with here is simply this case and the facts of this case as presented by the defense. And what I'm trying to ascertain is why these defendants are unwilling parties to disclosures of their otherwise privileged materials or privileged sessions or privileged conversations or communications, and why a defendant in a diminished capacity situation is a willing party.
Well, they're both unwilling parties in the sense that the people make the allegation that a certain act was done with malice aforethought. In the diminished capacity situation, the defendant responds to that allegation by saying, I had no malice aforethought because at the time of the crime, I had a mental or emotional defect or condition, or I was insane as a result of some mental or emotional defect. In our situation, we're an unwilling party because, again, the people make the allegation that this is an act done with malice aforethought. And our response is we had no malice aforethought because under Flanell and the self-defense instructions, we had a fear, which is a state of mind at the time of the crime, which negates malice.
Well, if
That argument does not depend on the presence of a mental or emotional condition as used in 1016.
Can I take the this one?
You certainly can. Again, this situation is different than a case where a defendant takes the witness stand and says, I was in fear, and these are the reasons why I was in fear. You have introduced in this trial expert testimony, and that's why the court has waited until that testimony has been presented. You have presented expert testimony to the effect that these defendants are in a different class of individual because of certain experiences they've described, and because perhaps based on testimony offered by the defense, because of certain biological changes that have occurred in their brains that have caused them to react differently than a reasonable person. And that basically puts this case in a different posture than the typical self-defense case where there is a flannel situation.
Could I then, in light of the court's comments, move on to the second point I wish to make, which is that
Well, did you want to respond to my first point here, or have you covered the ground?
Well, I think we've covered the ground. I disagree with the court that we have done anything to raise a mental or emotional condition. I understand the court's position, but
All right, let me say this in response. I think Ms. Abramson has something to say as well. It's a very interesting discussion. Section 29 of the Penal Code is an issue or raises an issue that we have discussed as well, primarily at the sidebar, but it's come up different times in our discussions during the testimony of experts. And that is a code section that was adopted by the legislature prohibiting or limiting certain types of mental state evidence offered by the defense to negate elements of murder, such as malice aforethought and intent and things of that nature. And there is a history to that particular section. And there has been discussion during the testimony of experts in regards to whether that section applies. And at some points during the cross-examination of the experts by the prosecution, the defense even cited Section 29 of the Penal Code as authority for its position that the people's questioning went beyond what was permissible by law. I think that was an objection made by Ms. Abramson. At the time that there was some cross-examination, Mr. Burt passed a note, as I recall, to Ms. Abramson, and my observation at the time, which I made to myself, was that that's probably what Mr. Burt was telling Ms. Abramson. Section 29 of the Penal Code might be a good objection. And sure enough, she made the objection and the court sustained it. Section 29 of the Penal Code talks about limitations on certain type of expert testimony when the defendant's, quote, mental illness, mental disorder, or mental defect shall be in play, end quote. Or those are the words that used in Penal Code Section 29. And there has been argument in relationship to whether that applies to this case and or to cases such as this where there is evidence of battered person syndrome introduced. And that section is discussed in one of the cases that we have been referring to during the course of the cross-examination of the experts. And the name of the case escapes me at the moment. I don't have it here, but we've been referring to it, Eris, yeah. The Eris case. And Eris found that in a trial of a defendant who was asserting battered woman syndrome, that Section 29 precluded certain type of expert opinions being rendered. And again, Eris was dealing with a situation somewhat analogous to the evidence introduced here of battered person syndrome. And although there was some conversation or discussion in the opinion as to whether there was any labeling or attempt to label these things as a defect, a mental defect, the appellate court ultimately found that Section 29 did apply. So when you're arguing that this is not a mental defect or does not relate to Section 1016, I think we ought to consider that as well.
Well, I do, and let me respond to that.
All right.
Because I think it's important to take into account the different purposes behind these two provisions. Section 29 is designed to prevent essentially experts coming in and telling juries how to decide the case. It's concerned with the ultimate issue, and the history of that provision, I think, was a reaction to experts coming in saying this person did or did not have a premeditation and deliberation, and the objection to that sort of testimony was that it was for the jury, not for the expert to decide. And in that context, the court, I think, would be right in reading broadly the idea of mental disease or defect. 1016 and the whole area of privilege, the law under those sections provides that the privilege and any exceptions to it have to be read narrowly. So I don't think you can transport Section 29 into a privilege analysis because it doesn't take into account the fact that the courts have been concerned with narrowing the scope of the privilege. And I think that's what the Supreme Court's talking about in the Lifshitz case, is that in reading 16, the court has to adopt a very careful precision approach. Otherwise, you run into constitutional difficulties with that particular exception. And that consideration is simply not present in Section 29. So it's not a one-to-one analogy here where the court can transport Penal Code Section 29 into the 1016 context.
Well, the only reason to analogize it at all is that if an appellate court is willing to characterize battered person syndrome, or whatever label you want to put on it, as a mental defect for the purpose of applying Section 29 of the Penal Code, then a mental defect would seem to be more pronounced and something of a greater magnitude than a mental or emotional condition.
I understand the court's point now, and I think it's important to point out that neither defendant has had an expert testify that they have or are now suffering from battered person syndrome. There's been testimony in general about what the characteristics of that syndrome are, but no expert has offered the opinion that that syndrome, as opposed to specific characteristics, is present in this case. And I think it would be a different case if our experts had said, my opinion is that Eric or Lyle Menendez was a battered person or suffered from battered person syndrome and was suffering from that syndrome at the time of the crime. I don't think we have that testimony.
I'd be hard pressed to find that you don't have that testimony in this case based on what's been presented here. It certainly seems that that's what the defense has been putting on by all these expert testimony.
I think this is a point that Ms. Abramson wanted to address.
Actually, this is the point Ms. Abramson wanted to go to lunch, but I'll address this first.
Okay.
I think that one of the things that is being lost sight of here is that what the experts were testifying about was not a mental state, a mental condition, or a mental defect peculiar to these defendants or peculiar necessarily to battered persons, but a set of normal responses to certain experiences in their life, and responses that virtually any person would also share. And I think the problem is that simply the state of understanding of the effects of trauma has outstripped 1016 and other in case authority and Eris as well. But here's the ultimate point. There are cases in California, Pena is the one that always comes to mind, but there are a series of self-defense cases. And the operating emotional state in every self-defense case is fear. And certainly in every imperfect self-defense case, the operational aspect is fear that overcomes malice. Now, there are numerous other cases where there has been a pre-existing relationship between the defendant and the victim. And as a consequence, where the victim, for example, has previously assaulted or threatened to harm the defendant, the court has always recognized that a defendant in that situation, because of their special knowledge, if you will, about the victim, can anticipate an assault early, and that the reasonableness of their behavior or the good faith of it should be measured from the perspective of their pre-existing relationship with the victim, and that their right to act sooner than might be objectively or factually imminent to someone who had no such pre-existing knowledge and no such relationship has been reaffirmed over and over by the courts. Now, what we have done in this case is no different than that. All we have tried to show is through a history of behaviors that these defendants had a particularized special knowledge of their parents' threateningness or fear-inducingness. And it is no different than Mr. Pena in the bar of the Mexican Village restaurant when his tormentor, if you will, came in, who had been spreading rumors in the community that he was going to get him, who had was telling people to let Pena know that he was carrying a gun to shoot him with. And when the victim came in the bar, before he ever pulled out his gun, based on his special knowledge and his previous knowledge, simply because of the way he was walking towards the defendant, the court ruled that in that case, Pena may have had a right to act sooner, and the reasonableness of his behavior and the good faith of his behavior had to be based on this pre-existing knowledge. Now, we have done no more than that, except base it on what we now understand goes on between abused persons and the people they abused. But that is not a mental or emotional condition. It is a normal condition. And I think what we've tried to
Well, there's number one, there's no inconsistency with a mental condition also being a normal condition. Much of your discussion so far relates to objective versus subjective reasonableness, and it's an issue that we will deal with in discussions of jury instructions. But really what has occurred here is over a long period of the trial, the defense has put on evidence that is unique only to the defendants, to the point where their mental state was unique only to them. And their mental state or condition is what has been presented to the triers of fact, and the experts have so testified about their condition, about their fear, about all the things relating to them as individuals. And you have basically postulated a situation here that relates only to the defendants and their mental condition and no one else.
I don't believe that's what we've done at all. Obviously, the specific facts of their life relate only to them and no one else, but the condition, if you want to use that expression, that it left them in is anything but unique to them. I think everyone who has testified as an expert witness in this case, going even back to Dr. Briere, who testified to open the defense, talk about the fact that all people in these circumstances develop this hypervigilance and special knowledge. People who are frightened stay frightened. That is not special to these defendants at all. And people who have been previously threatened by someone have greater reason to fear. That's not special to them at all. If anything, we've tried to show that the way they reacted under these circumstances are the way that anybody with anything like a similar background or even a dissimilar trauma background would react. So we have not been trying to show that they are unique. Certainly the facts of their existence are somewhat unique. I suppose every one of our lives is somewhat unique. But what we've been trying to show is patterns of abuser behavior and patterns of how abused people deal with that behavior.
All right, I don't want
But
to
my
get
concern
this
is-
discussion subsumed into
But my
some
question-
broader discussion of issues that relate to jury instructions. So let's focus
I'm not.
just on the
All right.
issue here of Evidence Code Section 1016.
Well, here's what I'd like the court to focus on then. I would like the court to focus in trying to think through this. If Pena was really frightened by this guy and therefore acted out of fear, does that mean that in every self-defense case where there's pre-existing knowledge, if Pena had 10 years of therapy, the privilege is gone? I mean, I think it's very different when you're putting on a mental state having to do with a disease or defect that is a diagnosable condition where one would hope in therapy notes to find precursors to that particular mental state, where one would hope to find someone was in treatment for the implicit defect or disease or condition that would ordinarily bring one to treatment. But if any time you put a state such as fear an issue, or fear based on pre-existing relationship an issue, that means your therapy records are open. Makes no sense, because fear is not something you would ordinarily be going into therapy for. And particularly in this case, we know that these defendants were not sent to a therapist because of any perception that they suffered from.
Okay, you're going way beyond
No, but
our
I'm going-
discussion here. You really are. You've had testimony from your own experts that the defendants would require therapy to work through all the abuse that they took.
They may have, but these parents.
Okay, so you just-
deal for that purpose.
That doesn't matter. That's not the issue that we're discussing. You're
think
going
the
well
reason-
beyond that.
No, I think the reason why the comments to 1016 are focused on diminished capacity and insanity is because those are the kinds of mental conditions that one might have had treated in a therapeutic setting. So there could be some nexus between the notion that if a defendant puts that kind of condition in issue and had pre-existing therapy, it makes a certain amount of logic to assume that those issues were dealt with in therapy, or that the whatever notes of previous treatment might bear on that. And what's wrong with applying it in a case like this is, given the particular mental state, if you will, the negation of malice is sort of a minus mental state. There is no reason to believe that that is the type of issue or condition subject to therapeutic treatment, or that would have been treated in therapy, or that looking at previous history or previous notes or previous records would shed any light on. And specifically to fact drive it in this case, we know these defendants were not sent to Dr. Oziel to deal with their child abuse. That's clear.
All right, that's also not really relevant to this issue. Yes, Mr. Burke.
I was just going to add one other point in the court's had asked earlier what the difference is between what was put into issue here and the diminished capacity situation. And one difference is that the expert's testimony in this case is really focused on a statistical type of analysis. They're testifying to symptoms that have been present as a result of reviewing a number of these cases, which all have the common pattern of long-term abuse. And that seems to me different than a situation where the defense tenders an expert who is relying for his diagnosis or his opinion on the defendant. It's all internal to the defendant when you put on a diminished capacity or insanity defense. And it's the source of the information in that situation is a defendant exclusively, whereas these experts, it seems to me, are going outside the realm of the defendant. It doesn't matter what the defendant says about to the therapist, the expert is still in a position to testify about the general characteristics of battered person syndrome. And that testimony is based on a large number of cases external to the defendant. And the whole idea of the waiver of the privilege in the diminished capacity insanity situation is it's unfair to base a defense on internal information stemming from the defendant and not give the other party the opportunity to get the same access, which is typically what's in therapy notes is the defendant stating what his internal process is. And so I think that is a difference here.
Well, except your experts interviewed the defendants and have spoken about their particular situation, not in general. Their testimony has been tailored to the defendants themselves and not to a general description of battered person syndrome or whatever way you want to characterize it, and how it could affect an individual, but it was specific to them as to times and their emotional and mental condition at various times. It was all related to what they said and what they said to the therapist or the experts. It's much different than just an objective analysis of facts and interpretation of them, but it's related specifically to what the defendants told them and how they are their evaluation by the experts.
The other thing I wanted to add, Your Honor, is there is a difference in the evidence as to, the court mentioned the limbic system testimony of Dr. Burgess, and there is a difference in the evidence, I think, between Lyle and Eric Menendez in that regard. She offered a specific opinion as to Eric Menendez that was not offered as to Lyle, and so I think there's a different analysis as to Lyle Menendez on that particular aspect of it.
If I could be heard briefly on that, I'm not sure that Mr. Burke's characterizing that is accurate, but I don't think it matters because she was not talking about a mental condition. She's talking about an automatic biological response, and one obviously that could not be, one that has no logical history in therapy, since it's not anything you could actually measure anyway, except at a time. Automatic biological response bears on mental or emotional condition because it's neither. It's a physical condition.
All right, did the people wish to respond to the argument so far?
We're not done.
With the abolition of the diminished capacity defense, I can't think of a defense which would more completely put a person's mental condition or emotional condition at issue than the defense presented in this case. To say that because it's not a syndrome or defect or disease is recognized by the DSM-3R is to beg the question of the wording used in the statute is mental condition or emotional condition. Fear is an emotional condition. These distinctions that the defense is trying to make do not amount to legally significant distinctions. And just because the commentary included as an example diminished capacity or insanity, I'm sure at the time that the people made the comments, they had not yet contemplated the introduction of evidence code section 1107 and other kinds of novel defenses which use that kind of testimony. If this is not the kind of testimony which raises the mental condition or emotional condition of the defendant, then I don't think this could ever be used in a criminal case where there is such a defense presented, because there has been a complete, exhaustive, detailed description of these defendants' emotional and mental conditions.
All right, Mr. Burt, you wanted to go on to something else, or just give me the area that you wanted to.
The basic idea was if the court,
Even if the court were to find that there was some mental or emotional condition put into issue here, that the procedure outlined in the Lifshitz case is that the court at that point does not automatically disclose everything that people are seeking, but that the next step in the analysis would be for the court to go in camera at our request, and we would make that request. And at that point, it's our position that our burden would be to point out in general to the court, without disclosing the content of the sessions, the subject matters that are covered in the therapy sessions that are sought by the people. And the court at that point would be required to determine, given what we said the content of those sessions are, whether particular subject areas are directly relevant to the specific mental condition or emotional condition we have put into issue. Really requires that as an initial step, the court, or the prosecution actually, since they're the party here, indicate what mental or emotional condition we have put into issue. She just indicated fear. And if that's the mental or emotional condition which the court's going to say brings this section into play, then it seems that under Lifshitz, the court has to conduct an in-camera hearing as the next step and allow us to argue as to why what's in these tapes or notes court cannot require in an in-camera hearing total disclosure of the contents of the privileged material, and that the most that the court can require, and this is footnote 23 of the opinion, is some general outline by the defense as to what the privileged information is without requiring total disclosure. So we bring this issue up now because the people obviously wouldn't be part of the in-camera hearing.
All right, what is the people's response to that? As to the mechanics of how this matter should next proceed if there was a finding by the court of a showing made by the prosecution for 1016 of the evidence code to apply, as to whether the court is required to be limited to the good faith representations of the defense counsel as to what is and what is not on these notes or in these notes.
Well, I think the defense wants to waive the privilege and have the court go ahead and review them. So
That's not what they said. So just the opposite.
sorry. They don't want the court to. Well, it seems to me that under 915B, that if the court can't rule on the claim of privilege without disclosing the information, the court can compel it. But I had spoken with Mr. Bird earlier about what the next step would be, and he proposed to me that the court review the information.
No, that was, if you understood that, you misunderstood, because our position is, as I just stated it to the court.
All right, I misunderstood the position as just stated to the court. Can someone give me a synopsis of what that we, I wasn't in the room.
Let me rephrase it. This is the footnote 23 from Lifshitz. It says, although ordinarily a patient cannot be required to disclose privilege information in order to claim the privilege, citing evidence code section 950A, because the privileged status of psychotherapeutic communications under the patient litigant exception depends upon the content of the communication. A patient may have to reveal some information about a communication to enable a trial judge to pass on this claim of irrelevancy. And it's our position that that means what it says, is that we are not obligated to disclose the entire contents of these sessions in order to have the court rule on a claim of privilege here, and that our burden is to disclose what the subject matter of the communications are so that the court can determine whether it's relevant, directly relevant to the emotional condition put into issue.
And if the court can't make such a determination and you are claiming the privilege, what happens next?
I've read this opinion 5 or 6 times, and it's hard to determine what happens in that event.
Well, it seems just logically, if you are asserting the privilege, you have the burden that you would have to go forward and disclose. Otherwise, there would be no way of evaluating the privilege. I'll see how else could be done. The law didn't contemplate the holder of the privilege to be able to prevent disclosure and thereby prevent a hearing on the matter and resolution of the matter, and at the same time provide an exception under section 1016. It wouldn't make sense.
Except the court says in the text to that footnote I just read to you, a patient may have to delimit his claimed mental or emotional distress or explain in general terms the object of the psychotherapy in order to illustrate that it is not reasonably probable that the psychotherapeutic communications sought are directly relevant to the mental condition that he has placed in issue. In determining whether communications sufficiently relate to the mental condition at issue to require disclosure, the court should heed the basic privacy interests involved in heed the basic privacy interests involved in the privilege. In general, the statutory psychotherapist patient privilege is to be liberally construed in favor of the patient. So the court speaks here in terms of, in general, explain in general terms the object of the psychotherapy. That sounds like the court is contemplating that we, in general, state what the nature of these prior sessions were so that the court can make that determination. But 915, at least as interpreted in this opinion, would seem to block the court from forcing us to reveal the entire sessions.
All right, I'll let the people consider that matter and we'll resume at 1:45. I was going to respond to the inquiry.
Yes. It appears that the court intermingled the concept of privilege with relevancy, which, in other words, it won't be privileged if it's relevant, but if it's not relevant, it retains privilege nature. I think that's what the court is saying. And the court determined that in order to determine what is or is not relevant, that it's the patient or the holder of the privilege who has the burden to make a showing that the items at issue are not relevant. So, and then it also discusses in footnote 23 that the court might permit disclosure ex parte in chambers, which seems to run afoul of evidence for section 915A, which indicates that if the person doesn't want to make the disclosure, the person doesn't have to. But in this particular case, it appears that if Lifshitz is to be followed strictly, the defense would have to come forward with a showing that the information sought to be disclosed is not relevant to issues that have been raised by the mental condition. It is the people's position that the mental condition raised by the defendants deals with a lifetime of mental conditions and a lifetime of emotional conditions, and therefore, because of the broad nature of the mental condition or emotional condition raised by the defense, that all of this records would be relevant. However, if the court found that it's only issues relevant to the murders, then it appears from reading the Court of Appeals decision that at least the November 28th session did have dealings with the homicides, and as to the December 11th, it appears that it's hard, the Court of Appeals decision is less clear as to the contents of the December 11th session, but it focused on the family constellation and the relationship between the defendants and their parents, which would be germane to the issues raised in this particular case as to the state of mind at the time of the killings. But it seems that it's incumbent upon the defense to make a showing. And yet it appears to me that Lifshitz has left this court without a feasible way of implementing its decision. Because it seems to me if something is not privileged, then the court can look at it. And if the court can't look at it, how does the court know whether or not it's relevant? It seems to have locked the court into some sort of legal never land.
Well, Lipschutz is, first of all, a case that should be viewed in its context as a discovery matter. And the issue related to a lawsuit filed by the patient and a discovery matter that related to claim of privilege by the psychotherapist. All of those matters thrown into the mix put the case before this court in a much different posture. But footnote 23 of the Lipschutz opinion discusses this matter, and I assume that's what you've been referring to and what was referred to by Mr. Burt this morning. And the burden is on the defense or the holder of the privilege to establish that there is no relevance to these matters contained in the communications, not on the court or the prosecution to show that there is relevance, but on the holder of the privilege to show there is no relevance. And I suppose the matter is one of proof. If the defendants, holders of the privilege, don't meet the level of proof to the satisfaction of the court, then they don't show that these matters are irrelevant. And they are subject to disclosure if the court finds that Section 1016 applies. It's that simple.
Well, and the language in the opinion itself at headnote 19 says that the burden is on the patient, so it's not just the footnote.
Well, head notes are not,
Sorry, it's not the headnote, it's page 436, which starts with headnote 19 in the words, because only the patient and not the party seeking disclosure knows both the nature of the ailment knows what the nature of the ailment for which recovery is sought, etc. So it says right in the body of the opinion that the burden is on the defense.
Well, we never acknowledged otherwise. But the point of bringing this up this morning was to say that we did in fact have the burden, but to clarify the issue before we went in camera as to how exactly the procedure would work, because our argument is that it seems from the portion that I quoted to you this morning that Lipschitz is saying that if the patient comes forward with some general outline of what the prior therapy sessions contain and can show based on his representation that those general areas covered in the prior sessions are not directly relevant to the mental condition put into issue, that the burden is satisfied. And the reason we bring it up now is to try and clarify what our burden is. The court could, of course, say, well, you don't meet your burden unless you reveal all the privileged information so that I can rule on it in light of all the information. But that seems contrary to what Lipschitz says the proponent of the privilege, the burden is, because they do talk about the patient's duty to come forward and state in general terms what the nature of prior psychotherapy is. And it does not seem to contemplate setting before the court all the privileged information in order for the court to rule on a claim of privilege. And the other aspect of it is, I think the court is very clear that relevancy in a general context is not what the court is talking about, because at 435 of the opinion, the court says, communications which are not directly relevant to those specific conditions do not fall within the terms of section 1016. Disclosure cannot be compelled with respect to other aspects of the patient litigant's personality, even though they may, in some sense, be relevant to the substantive issues of litigation. So the court apparently is adopting a very narrow interpretation of what relevancy is for the purpose of ruling on the exception. And we raise this issue now in case the prosecution has some disagreement with that concept, but it would be our position in the in-camera hearing that although the sessions may contain relevant information in the sense that it may be relevant to some issue which has been raised in this case, it must go further and be directly relevant to the specific mental condition or emotional condition we put into issue. And I'm not sure we've yet delineated what that mental or emotional condition is. The people seem to take the position that their entire life is an issue, but that's not a mental or emotional condition.
no, that's clearly incorrect, and it's not that broad. The court would never contemplate such a broad interpretation of the mental condition or mental state.
So I think for the people to meaningfully participate and do so in light of the fact that they're not going to be present at the in-camera hearing, the court should resolve the issue of what mental condition or emotional condition has been put in issue, and then at that point go into camera and allow us to sustain our burden of proof as to why specific areas are or are not relevant to that specific mental or emotional condition.
Well, before we get there, let us just resolve the issue of whether 1016 applies at all so that we don't go any farther than necessary. Does anyone have anything else to add in that area?
Just a separate issue of the attorney-client privilege, but I assume the court wants to deal with that separately, or?
Well, it would seem to me, I don't know how you want to approach it, but if that constitutes a separate privilege that would insulate certain of these communications, then you would want to address that prior to going into an in-camera hearing, obviously. Since
I think so, and so maybe I should address that.
All right.
We cited to the court cases which indicate that the dominant purpose test, which the prosecution is relying on to make their argument that the attorney-client privilege doesn't apply here, isn't applicable in this situation. It applies to corporations and whether an employee of a corporation can claim the privilege on behalf of a corporation. But the two cases we cited to the court, Gonzalez and Suzuki, both say that that dominant purpose doctrine has no application outside the corporate context. And
Do the people dispute that?
No, Your Honor. In fact, I think it's actually ace the people's position. That in fact, if that particular doctrine is to be rejected, then we are in fact stuck with the findings of fact which have already been made.
All right, I just wanted to know whether you disputed that since you cited that as your
Right.
position, which obviously was incorrect. All right.
so then it seems that the question becomes, are the findings of the Supreme Court or of Judge Albrecht inconsistent with the position taken by the defense now to such an extent that we have somehow waived the attorney-client privilege? And there are also issues as to whether or not the privilege applies at all. But it's our position that based on the in-camera showing that we made to the court that it does apply, that the Clark case talks about the privilege, both privileges applying in a situation where statements are made for the purpose of obtaining a diagnosis for counsel's use in preparing a defense, and that sort of statement is subject to both the psychotherapist patient and the attorney-client privilege. So the fact that the Supreme Court says that these sessions were for the purpose of therapy does not exclude a finding based on the evidence we presented to the court. And also, by the way, based on the evidence that was in front of Judge Albrecht, that the December 11th session is covered by the attorney-client privilege.
The people argue in their brief that you didn't raise that before the Superior Court and the appellate courts when the hearing occurred in 1990, and therefore you are foreclosed from raising it now. That's one of their positions. The other position is that since they weren't there, you must have raised it, and it was resolved against you and now can't be raised here.
Well, if I may address the latter first.
All right.
I think the court can resolve that did not happen by looking at the transcripts that the court has. In its
Yes, I would so find that was not part of litigation at that time from looking at the transcript. Yes, Mr. Burke.
Well, I was actually going to take the other position, which was
resolved against us.
it was raised.
Because of the findings of Judge Albrecht, you're saying it was raised?
Well, no, I'm saying it was raised at page 99 of the hearing transcript on June 15th, 1990. We provided these pages to the court, and we'll do so again if the court.
Well, I have the transcripts again, which
This is
June.
the transcript of June 15th,
All right.
1990, page 99,
Okay.
in which there is the issue of the attorney-client privilege with respect to the December 11th session is raised.
Okay. Well,
And it's our
certainly look at that.
position that Judge Albrecht did make a ruling with respect to that privilege at that point. But even if he did not,
Well, let's assume he did, and I, quite frankly, did not observe that in the transcript. Let's assume he did. Why is that binding on this court?
it's not binding at all. It's just in terms of the issue of waiver. I don't think we've waived the issue. And I was just going to say that even if Judge Albrecht did not make a finding, I don't think there's been anything done up to this point that constitutes a waiver of the privilege. 1524 talks in terms of the holder of the privilege may raise claims of privilege. It certainly does not say that he must raise those claims of privilege or they are waived. And the people have a case to cite to the court which deals with a situation where the proponent of the privilege in an open court setting reveals the contents of the privilege and no privilege is claimed, and that constitutes a waiver certainly. But this was an in-camera hearing, and the fact that the prosecution can make an argument of that the privilege was not submitted at that point, I don't think constitutes a waiver.
All right. Do the people wish to be heard?
Well, we're at a bit of a disadvantage since we are not privy to the transcript of the hearings.
No, you're in a substantial disadvantage.
Yes.
That's unfortunately the posture of this
Right.
situation.
Yes, what I would like to raise to the court is the case that I found during the lunch hour, Calvert versus State Bar, which is the case Mr. Burke was referring to, which is 54 Cal 3rd, page 765, and then at page 780, which deals with the fact that Evidence Code Section 912 indicates that if you don't raise the privilege in an opposite at a place where you can raise the privilege, that failure to raise the privilege is a waiver. And it would be the people's position that the in-camera nature of the proceedings in front of Judge Albrecht, rather than just being a dissuader of the defense from raising this privilege, would have been an enhancer of raising all such privileges as available, especially in light of the appellate review, which was ultimately sought. 1524 of the Penal Code does not abrogate the dictates of Section 912 of the Evidence Code. It's the people's position that whether or not, and we don't know, if the privilege was in fact raised at those hearings, it should have been raised, and that failure to do so constitutes a waiver under 912. It is also the people's position, as I stated this morning, that the findings of fact in this particular case, which were obtained after lengthy in-camera ex parte hearing with the defense, should not be disturbed by this court, especially in light of the fact that they've been overruled by the Court of Appeals and then reinstated by the Supreme Court.
Well, the Court of Appeals decision is not any legal precedent, so it doesn't really help to cite it.
All right, well, but the Supreme Court said quite specifically in Menendez versus Superior Court that the findings of fact were to be maintained because they were.
The trial court's findings of fact.
Yes, the trial court's findings of fact, and those were findings of fact on the exact same issue that we're dealing with today, which is the nature of the relationship between the defendants and their psychotherapist on December the 11th.
There's
Let
also,
me just say one last thing.
Sure.
The defense has cited no case for the proposition that in getting a second by
going to indicate to the court that 912 talks about failure to claim the privilege in any proceeding in which the holder has the legal standing and opportunity to claim the privilege. And in this specific case, there is a factual issue as to why, if this was the case, the privilege, the attorney-client privilege, was not raised in the way that the people say it should have been raised. It's our position it was raised at page 99 and sustained. But if the court were to find otherwise, we also have a factual issue that we believe goes to the issue of whether there was an adequate opportunity at the time of the 1524 hearing to raise the issue.
And how is that before this court?
Well,
It
Well-
hasn't been presented so far.
well,
No, I think it has been actually.
Well, it was alluded to,
Presented.
but there was no presentation or representation or evidence produced as to why it wasn't.
No, that's true. And this is the first time that people have raised this theory as to this waiver.
No, well, they do raise it in their brief that they filed on the subject to the extent, and it's a good point. It's hard to argue with it that if it's a matter of claim of privilege and you were litigating rather forcefully in the Superior Court this claim of privilege in regards to these communications, and the privilege you were asserting was the patient-therapist privilege, and there was another privilege out there that you knew was a viable privilege, that would insulate these communications or some of them from disclosure. Why didn't you raise it at that time so that the trial court could rule on it and the appellate courts could rule on it, so that the matter would be for once and always resolved, so that you would not now be at this posture at this phase of this trial? That,
We do have an answer to that question.
okay.
And I think it's an answer that goes into a attorney-client privilege and conflict of interest situation with respect to the attorney then representing the parties that could have raised that issue.
and I think if the court looks at the transcript, you will see there is a struggle going on. And from the Eric Menendez standpoint, we were attempting to lay a factual basis for the assertion of that privilege, and we were stopped by the attorney for Lyle Menendez, who was in a conflict position vis-a-vis litigating that privilege. And so I don't think we had, certainly we didn't have, since we couldn't force him off the case and he was blocking our attempts to inquire into the factual basis, the opportunity to fully litigate that issue in those proceedings with that attorney. And by the time that attorney was no longer on the case so that the conflict issue was resolved, we were in litigation limbo and stayed in litigation limbo, basically. Everything stayed until the case got here when we raised the issue.
Well, you raised it in response to the people's motion to obtain
Well,
the
Yes, because the Supreme Court
psychological records.
the Supreme Court had ruled that that tape was privileged, so there was no need to raise the issue before then. And as far as we were concerned, there was no need to litigate an issue when another privilege had already been sustained. So when they filed the 1016 motion, that's the time when it became appropriate to try to litigate it.
All right, and did you feel that you wanted to put something on the record in that regard, or you feel that you just articulated whatever it would be that you would have put on the record?
I wouldn't mind putting it on record in camera.
All right, I know you alluded to this before, but it never really materialized in any evidence being taken on that subject. What is the people's response to that? That there apparently was a conflict of interest of some form. I don't know what it was as to how it was resolved, but there was some assertion of a conflict of interest relating to counsel representing Lyle Menendez at these earlier proceedings. And assuming that that precluded a claim of privilege, should the defendants now be prevented from asserting that privilege?
It's hard to comment when, first of all, the defense has indicated on page 99 and 15 that the privilege was sustained. So I have no idea what that was.
Okay, I'm going to look at that. I did not see that in the transcript. I'll certainly look at it.
It seems to me that as far as at least Eric Menendez is concerned, that counsel was not without recourse in seeking, if in fact Mr. Chalip was a witness, he was not without recourse in seeking to have him removed in order to have him be a witness in order for Eric Menendez to assert the attorney-client privilege. I don't really understand it. It seems to me they're saying that because a prior attorney was incompetent or unethical in seeking to continue to represent a client where he had a conflict, that people are now put in a position of disadvantage. In that case, let me just draw an analogy. If we were having a 1538.5 hearing and people were seeking appellate review and there were factual findings made by this court, I would have to think long and hard about any court that would allow the people to then claim a different theory once the case had been litigated and sent back down. It seems to me that at the time that this issue was raised, it was incumbent upon the defense to not only raise the attorney-client privilege, but if in fact there was a conflict between one of the attorneys and this particular theory, the interest of the client should have prevailed. I don't know precisely the dynamics of the representation of Lyle Menendez and Mr. Chalip's role in it. So it's hard for me to comment further or to speculate as to what might have or should have happened. But it seems to me that the people are now being prejudiced once again, just as in the handwriting refusal where the defendants were allowed to take advantage of the fact that their attorneys told them to violate a court order. The people are now put behind the 8 ball once again because they are claiming that because of some conflict of interest, which they did not pursue at the time, they were stopped from raising this privilege and therefore they should get a second bite of the apple.
All right, I don't see these as any way comparable. We're talking about a much different issue and much different type of privilege being asserted, and the quality of the evidence is, or the type of evidence is much different as well. All right, anything else on behalf of the defendant in that on that subject, which is a limited one of the defense should have raised this earlier and didn't raise it and now is precluded from raising it or is bound by whatever happened before. Beyond that, going to the substance of the arguments, did you want to be heard further?
Well, just to indicate to the court that our position is not inconsistent with the findings of the Supreme Court. We are not claiming that before these sessions were solely for the purposes of therapy and now they're solely for legal purposes. Our position is that there's a dual purpose at work here, just as there was in the Clark case where the defendant is referred to a psychiatrist for the purpose of preparing a legal defense. The purpose in that case was to prepare for the defense. That would seem to be the primary purpose, and yet the Supreme Court held that both privileges applied. So there's nothing inconsistent with saying that both privileges apply in a situation. They can be for both purposes of therapy and for legal purposes. And so with the additional information that was provided to the court at the in-camera evidentiary hearing on this issue, I think the court is in a better position to determine whether that dual purpose was at work, and it's our position it was. And given that fact, that the attorney-client privilege would apply as to the December 11th session.
And Clark was a situation where there was a pre-existing relationship between the patient and the therapist prior to the attorney involvement?
No.
All right, let us assume the situation is one where there is a pre-existing relationship between the therapist and the patient, and that relationship was an ongoing one and would continue regardless of whether the attorney was involved or not. And the only issue related to whether or not a recording of a particular session was made on advice of counsel, but that session would have occurred anyway. Just assuming that hypothetically, what would be your response as to whether the privilege would attach?
Well, that seems to raise a factual issue as to whether the session was for legal purposes. And I think our factual record is that that meeting, not just the taping, but the session itself, was not going to take place unless a certain person said that it was going to take place, and that certain person said it was going to take place for a specific purpose. So I don't think that hypothetical is this case, but I think in the hypothetical posed by the court that raises a real issue as to whether the session was for legal purposes. It would seem in that situation that an argument could be made. It was not. It was strictly for therapy purposes.
Well, what if other sessions occurred after that tape recorded session that were for therapy? And the inference be that the tape recorded session was also for therapy, and the only input of counsel was to make a decision that session should be tape recorded or not, but the communication itself would have occurred whether taped or otherwise.
Let me answer that for just a moment. The problem with that analysis and trying to apply it to this case is that there is no way to know, no way for us to know, or for anyone else to know, whether sessions that occurred after the one in your hypothetical that was tape recorded in fact shared the same content or even a similar content to the one in question. And if we assume hypothetically the one in question had a dual purpose and one of it was legal, we could also, I suppose, speculate that other sessions after, about which we have no records whatsoever.
I mean, no notes, nothing.
Nothing. And we could assume that the others perhaps focused on completely different issues, still within, the very wide range that can somehow adhere to therapy. But I think it's speculating to assume that the subsequent sessions dealt with the same subject matter. Session of 1211 could be a closing chapter in a very short book, and another book could have opened with the next session, which would have completely different topics. Let me just put it that way, since we're not in camera. But it could lend itself to that kind of interpretation.
All right, Mr. Burt, you had something to add? Or?
No, I think she covered the point I was going to make.
Your Honor, I have one more point I'd like to make. If in fact the defense, I don't know what's contained on page 99. I don't know if the privilege was sustained or raised or whatever.
Well, I'll look at it, and if that's what happened, I don't see any reason why you shouldn't be able to see it.
Right. But if in fact the defense feels that at this point they're entitled to have new findings of facts which supplement or supersede or whatever Judge Albrecht said, I think the people are entitled to raise a new issue, which is the fact of the information revealed by the special master regarding the playing of the tape by Dr. O'Zeal in order to get protection from the police. It seems to me that if in fact the defense is in the position to argue that they're entitled to new findings of fact, the people are also in the same position. But I just wanted to say that Mr. Burt said that that there could be a dual purpose, that is preparation of a legal defense and therapy. And the traditional usage of the attorney-client and psychotherapist patient is where the attorney sends his client or procures the services of a psychotherapist to evaluate and prepare the defense. And what really has to happen is the psychotherapist is engaged in aiding the attorney in preparing the defense. And in this particular case, when Judge Albrecht finds that the purpose was for therapy, that seems to be in direct contravention to the notion in this particular case that this was a preparation for a legal defense. And so the two.
Why couldn't a therapeutic session be used for legal defense as well?
I think counsel.
Because
I think counsel's confusing fabricating a defense with a legitimate one.
Well,
no, I
just, just in general. We're not talking about-
no, I mean, theoretically, that it's possible that you could get therapy and prepare your defense at the same time, insofar as preparing your defense makes you feel better. But it seems to me that the purposes of the session, one is to prepare the defense and one is to make you feel better. And those particular purposes seem to be not at cross purposes, but on parallel planes.
What if a session was recorded for the purpose of using the recordation of that session, which was a therapeutic session, for the purpose of presenting evidence in the defense?
Well, it seems like it's just a matter of record keeping of the therapeutic. It's basically the recordation is a record keeping device, the same as notes would be, but it seems that if the purpose of the session is for therapy, as Judge Albrecht so found, that you still don't have the situation contemplated by the attorney-client privilege where the session is for the purpose of evaluating a defendant for the purpose of aiding the lawyer.
Well, why does that be for evaluating? What if the treatment itself was going to be used in a defense? But what was disclosed during the treatment was of value in the defense.
It still doesn't bring it within the ambit of the attorney-client privilege.
Well, you're using
Okay.
the theory that it has to be only one use. If there's more than one use, then it doesn't apply.
But I think that was in fact, first of all, Judge Albrecht so found that it was for purposes of therapy. We know that the issue of the attorney being contacted before was raised in front of Judge Albrecht. So it appears.
Did Judge Albrecht rule, and I realize you're not privy to it, but I'm sure the defense will cite me to any such authority if there is any, and I'll look at page 99. Did Judge Albrecht rule that that particular session of December 11th was not also for the benefit of the attorney-client relationship?
I don't know. I mean,
Well, assuming he did not, then why is any ruling that he made inconsistent with the position of the defense that there was this dual purpose?
well, Your Honor, well, let me give a different hypothetical. Let's say Dr. Ozil had tape recorded all the sessions, and it had either bugged his office or had, in fact, tape recorded the sessions with the patient's consent. And then the attorney comes along and says, whoa, I want to use those in trial. Those might be helpful. That doesn't convert those sessions into an attorney-client.
No, but what if the lawyer did that in anticipation of those sessions occurring and said, let's record one?
It still is not done for the purpose contemplated by the attorney-client privilege. In other words, it is not done for the purpose of aiding in the evaluation of the patient or transmitting information to the attorney. It's rather a method of keeping records so that the attorney later on can have them if he so chooses. But the purpose, the attorney did not consult his therapist or send the defendant to the therapist for the purpose of aiding him in preparing or evaluating his defense. It was more a question of, if you're going to do it tape recorded, maybe we can use it later, which is what I think occurred, but I don't know. And that is a distinction between that and an attorney sending someone for consultation for the purpose of evaluation for litigation.
All right, what if, and this is what I posed in the hypothetical, the lawyer says tape it, and that's the only reason it was taped is because the lawyer said it was to be taped.
It's still the people's position that that is not what is contemplated by the attorney-client privilege, that it was not done for the purpose of communicating with the attorney. And it seems to me then that the argument should be made that all the sessions that occurred then after Mr. Chalick was consulted in December could be subject to the same claim, even though they weren't tape recorded. The information could still be transmitted to the attorney by Dr. Ozil for purposes of aiding him in preparing the defense. But since the defense is not claiming the attorney-client privilege to any sessions after that, we have to assume that that was not what he was, that was not, in other words, we have to assume that since they're not claiming the privilege as to the other sessions, that this claim of privilege is being done as an afterthought.
Well, we've heard there are no records of any other sessions, so The only critical session is the one that was tape recorded, where the defendants spoke with Oziel and was tape recorded.
But just because there are no records doesn't mean Dr. Oziel couldn't testify as to the content of the.
Well, but his testimony would be subject to this, regardless of objection, would be subject to the same challenge to his credibility as we've heard before. And it's just a question of fact for the jury. The jury's already heard his recounting of the sessions that dealt specifically with the issues in this case.
But if Dr. Oziel, let's say hypothetically, if the defendants had disclosed sexual abuse in the sessions after December 11th, I'm sure the defense would not be arguing this lack of credibility. The question really is that at this juncture in the trial, the defense chooses to attack his credibility. And even the defendants admitted the things he said which are helpful to the defense were actually said during the sessions. So if Dr. Oziel were to come in and say that on December, let's say 31st, the defendants disclosed something to him which was beneficial to their defense, I find it hard to believe that they would, first of all, claim the attorney-client privilege, and secondly, challenge his credibility. That is something that's fact-specific. But in terms of the genuineness of this claim, January of 1989 to Mr. Chaloff. There was the exhibit 90, I can't remember, 127, I think, or 227. So the defense could make the argument that all the other sessions were covered by the privilege because he'd been contacted. But it seems to me that just because an attorney says tape record the session doesn't satisfy the communication requirement of the attorney-client privilege.
I think what counsel neglects more is the notion that in order to evaluate these claims, you also have to look at the expectation of the client. And it isn't enough that an attorney said take the session. I think the court has before it a much broader record than that. But obviously, client expectation has a great deal to do with whether or not something happens or doesn't happen as a consequence of the attorney-client privilege. And just to make the record perfectly clear, if anyone ever tried to elicit from Dr. Oziel anything that was said at any other session, of course we would assert the privilege, and the people would have to make a prima facie case that somehow the privilege did not apply. No one has attempted to elicit such information from him. There are no records, as far as I know, indicating what that information would be, but that is simply an issue that has never come up for litigation. To make it clear, we assert the privilege to each and every session and always have.
Well, to make it clear, we are asking for all of Dr. Oziel's records. We're also going to ask for all of his testimonies to all of the sessions, whether or not there were records kept under the 1016. And so, but the defense is, as Eric Menendez is concerned, September of '88 through December of '89 and past that. We're asking for all of those sessions to be revealed to us insofar as they fall, that they are relevant. But the only one where there's this claim is the one that's tape recorded.
Well, I would assert both privileges for anything following December 8th, actually, 1989. But I'm not aware that there is any information to attach the privilege to. Dr. Oziel has not ever revealed any further notes. But if counsel just wants clarification, we assert both the attorney-client and the psychotherapist patient privilege to anything following December 8th.
Well, it's obviously difficult to deal with, not a phantom, but just to deal with something where there are no documentation. There is no documentation. The one that's at issue here, the one that people really want, is the one that has the voices of the defendants and Oziel. And that's really the one we're talking about. We can dance around it, but that's really the substance of our hearing.
The prosecution argument seems to be that since we're not claiming the attorney-client privilege as to all the sessions, therefore that shows that the claim of privilege we are making must somehow be invalid. But I think you can have a situation hypothetically where a patient is in therapy with a psychotherapist, totally unrelated to the legal process, and has a series of sessions with that psychotherapist and reaches a point where, for whatever reason, there's a decision made that that therapy is not going to continue because of a legal problem. And the patient at that point goes to a lawyer and confers with the lawyer as to whether or not the patient should continue to see a therapist. The lawyer says, in anticipation of a lawsuit which is yet to be filed, I see the dangers involved, but for legal purposes, my own purposes in preparing the case, which I eventually think is going to be filed against you, I think you should continue on and have other sessions. And if the patient does that, the sessions from that point on, it would seem to me, are covered by both privileges. And yet from outside appearances, it looks like the client is selectively invoking the privilege and is doing so based on a proper legal basis, and that's, or proper factual basis. And that's really the situation here. We can't reveal what the factual basis is, but I think that hypothetical is comparable to what we have here. So the fact that we are not invoking the privilege as to each and every session that took place prior to a certain period of time does not in any way reflect on the validity of the claim that we are making.
One
Well,
other
we haven't
section
gotten
I'd like to
anywhere.
cite to the court is section 955 of the evidence code, which says that a lawyer who received or made a communication subject to the privilege under this article shall claim the privilege whenever he is present when the communication is sought to be disclosed, and is authorized to claim the privilege under section C of section 954, which is a further argument as to why this should have been claimed in front of Judge Albrecht.
Any response to that?
Page 99.
Okay, well, I'll look at that. All right. Anything else now on this general subject? Okay, we've gone beyond the patient psychotherapist privilege to the attorney-client issue that has been, to some extent, litigated in this court, in that there was evidence presented at or near the time the people rested its case. There was some evidence presented in camera where the prosecution was not represented, but the defense obviously was, and certain testimony was taken. All right, then let me deal first then with the patient. Well, let me ask you this. Did you want to make your in-camera representations or presentation first on the attorney-client issue before we get to the findings? Or okay, well, let's do that then. And yeah.
On the record, we don't know who testified in front of Judge Albrecht. We know some of the witnesses who did, but we don't know all of them who did. And I'm wondering if the court could clarify for the record what items from those sessions in front of Judge Albrecht, which were ex parte in camera, the court is relying on or reviewing in order to reach a decision. In other words, does that require a waiver from the defense, or in other words, we have been precluded from seeing anything except that which the defense chooses to give us from that hearing.
I have no objection to counsel knowing who the three witnesses were who testified.
I mean, in this court or in?
No, in front of Judge Albrecht. I think that's what counsel's asking about.
Well, I've taken testimony here as well.
Right, I know, but in front of, did Mr. Chalif testify, for instance, there, or did the defendants testify? I mean, I don't know if the defendants testified about the attorney-client privilege or if they testified at all, but I think that for the record, for later review, the court might want to put on the record what portions of Judge Albrecht's hearings or findings the court has considered in making its rulings in this court.
Does counsel want to know who testified?
Yeah, just out of curiosity.
Who testified was Dr. Lucille, Judah Smith, and Detective Silver. And I recall listening. That's it.
Yeah, that occurred over several sessions.
Many
Right.
minutes.
And there were no other live witnesses who testified. Okay.
All right. Did the people have any specific inquiry that you wanted to be made in regards to what will be disclosed in this closed session? You've heard basically what it is the defense wants to produce that has to do with why the defense did not assert the attorney-client privilege at that proceeding, allegations that they were precluded from doing so because of then counsel for Lyle Menendez and his posture. Are there any matters that you wanted the court to inquire on?
At this point, I mean, I can't think of anything. If I do all the courts in camera, I'll write it down and send it to the clerk. But since I don't quite understand the nature of the potential conflict, and there's so much secrecy surrounding this, it's hard to formulate any kind of question.
Well, I think it's pretty much been laid out here as far as the circumstances.
It's hard to imagine why an attorney representing a client can't claim the privilege for that client. I mean, it happens all the time that an attorney representing someone also is privy to some sort of attorney-client privilege. I mean, we've seen it happen here in court. So what I don't understand is what could have occurred, not being a defense attorney, what could have occurred which would prevent an attorney from following his duty under 955. So I can't formulate a question for the court to ask.
Okay, let me, beyond that, before we go on to the closed hearing, we could do some other things in open court. What is the defendant, Eric Menendez's position in regards to Dr. Vickery in relationship to these privilege issues?
Dr. Vickery is covered by the attorney-client privilege as well as the psychotherapist-patient privilege. He was retained by me specifically for the purpose of helping in preparing the defense and the defendant for that defense. And we would be asserting those privileges to everyone.
And you have yet to make a decision as to whether he will in fact be a witness.
My decision as of this point, but it may change based on these rulings, and what the court may ultimately rule here is disclosable, is not to call him in my case in chief. That's my current feeling.
All right, what is the people's response then to the defendant's assertion that Dr. Vickery's notes, if there are any, are covered by the attorney-client privilege as well as the patient-therapist privilege?
Well, it would appear from the chronology that the claim of attorney-client privilege is much more valid as to Dr. Vickery than it is to Dr. Oziel. And we have no way or reason to dispute that he was retained by Ms. Abramson for the purpose of consulting with a client. So if that, and so to that extent, it would be our position that if he was treated, that the therapeutic portions of his notes should be disclosed, regardless of the attorney-client privilege, because of that purpose. From those parts of the sessions which dealt with therapy and dealt with the homicide, that those particular things should be disclosed to the prosecution because of the defense tender.
It's hard for me to envision how one could retain a psychiatrist to assist on a homicide case and somehow have all the discussions about the homicide non-privileged. I don't grasp that concept at all.
And it seems to me that the representation of the defendant, and I can do this in camera to the extent necessary, and to the extent the defense wishes to present their position, that the defendant's position is that Dr. Vickery was hired or retained to assist the defendant in preparation of his testimony, which whether it's therapeutic or otherwise would also relate to the attorney-client relationship.
Well, that's correct, and I think it is covered by the attorney-client privilege.
Well, that's what she said in her offer here. All right, let's go on to a few other matters here just before we close the hearing, and related to other witnesses here, just to shift gears. This morning, there was some reference to objections by the prosecution to the next phase of the defense, which after Dr. Conte would be joint witnesses testifying before both juries, specifically family members, sisters of Mary Louise Menendez. And the offer was that the defense wanted to go into prior history and specifically the childhood of Mary Louise Menendez. So let me briefly hear that offer. We've had various discussions along these lines, and I'd like to resolve this once and for all so we don't have to keep going over it.
Before I do that, I would just like to add a witness that we have scheduled, I'd mentioned before that we didn't put on the list for this morning, was Carlos Baralt.
Yeah, you did mention it.
You did.
I don't think he's subject to any objections. With regard to Joan Vandermolen, who is Kitty Menendez's older sister, and I realize we've covered part of this territory before, but it would be our offer of proof that she would be in a position to testify to the events which took place in Kitty Menendez's childhood home with regard to acts of violence against her mother, obviously Kitty Menendez's mother, with regard to acts of violence against her brother, Milton. Specific acts of violence such as punching in the face, resulting in broken teeth, throwing a brother up a flight of stairs, putting his head through a wall. She would also be in a position to testify that her father cheated on her mother, that it was very well known in town, that Kitty Menendez was tormented as a child by neighbors who said things such as, "Your father was over here last night." She could testify that although the father left the home when Kitty Menendez was 3 and remarried when she was about 6 or 7, he continued to return to Kitty Menendez's home 2 to 3 times a week for probably the first 4 to 5 years after leaving Kitty Menendez's mother, and that after that he was there about once a week, and then later on it tapered off to once a month, but it lasted for 20 years. So he was very much in the home during the time that she was growing up. That the result of this experience was that Kitty Menendez was very aware of the father's propensity for violence, very aware of the destruction to the mother's life as a result of him was fine until children came along, a message which Kitty Menendez repeated to her own children, that her mother, because of the emotional destruction of the marital relationship on her, was emotionally unavailable and consumed by her own problems, a pattern which Kitty Menendez repeated, that Kitty Menendez's mother would engage in certain behavior which was then repeated by Kitty Menendez in her own home with her own children, specific things such as pulling their hair and calling them dummy, that the primary message transmitted to Kitty Menendez and to other members of her family was the importance of being accepted, being perceived as someone who had made it, that when Kitty Menendez married Jose, she was subject to strong negative reaction from her own family because of marrying someone who was Cuban, but that once he became rich and successful, then she and her husband and her children became the family stars, the object of great admiration, and that this was extremely important to Kitty Menendez. Her sister Joan could also testify to the fact that Kitty Menendez was extremely secretive, and although they talked, she and her sister Joan talked on a very regular basis. They never discussed anything except the most superficial things. They traded recipes, etc. But the information that Kitty Menendez gave her sister Joan about the family was always that the children were at the top of their class, performing excellently in tennis, that her marriage was perfect, that everything was wonderful, never revealed anything with regard to the affair that she discovered in 1986, which sent her into this is in spite of the fact that she did reveal to her sister that she was on medication. She never explained the real reason and attributed it to the move to California. Those are the family history things that Joan Vandermolen would be in a position to testify to. In addition, in another area, it would be our request to have her tell the jury about the experience she's aware of in terms of her sister, Kitty Menendez's extreme criticism and apparent jealous reaction with regard to Lyle's girlfriends, which seemed to track all of the major relationships he had. She also is a witness to an incident at a tennis tournament where Jose, under very unusual circumstances, goes to his son Eric's room alone for a period of time, and the facts surrounding that. She could finally resolve the mystery of the relatives in Quito and verify that, in fact, the Anderson family did have relatives in Quito, and that Quito, to her knowledge, is located in Ecuador.
We have no objection to her testifying about the relatives of people.
For the location of Peter?
Or
But
where
it's
Keto
equity.
really is.
Thank you.
Tennessee.
She also was in the home after the death of Kitty and Jose Menendez, participated along with at least 4 or 5 other people, I believe, in the search of the computer, the location of the entry will, the size of that file, and the very public discussion of the fact that that information was there. And lastly, with regard to her presence in the home and that of others and the removal of items from the home at that time. So that would be our offer of proof with regard to Joan Vandermolen.
All right, did the people wish to be heard as to any of that offer?
I'd just like to put it in context. What the defense is talking about are acts of violence among and between the defendant's grandparents, which the defendants couldn't have witnessed because they were not even born yet, or she was only a child at the time. So it's not, we're talking about the defendant's grandparents' conduct, which seems to be rather far afield of the conduct of the defendants on the night of August the 20th. And I think we have exhaustively discussed this particular, the lack of relevancy of this particular kind of information, but we're talking about 3 generations. And I don't want to belabor that any further. I do want to say, as far as this, Mrs. Menendez being secretive with her sister, I think that there's already been testimony about the fact that she was secretive, but it could also be that Mrs. Menendez didn't feel comfortable discussing these things with her sister. Not all sisters are close, and so I don't know that this proves anything. And the criticism of the girlfriends was already brought up by Mrs. Barral. She testified about specific instances where Mrs. Menendez had been critical of girlfriends. And then as far as the relatives in Quito, and the removal of items from the home, the people have no objection to those particular items being brought forward. But as far as everything else that she has to say, it's either cumulative or it's remote.
Does that include the
Well, the computer search, I'm not quite clear what, that there was a search of the computer. I think Carlos Barral will be testifying to that. I would assume he
All
is.
right, I don't want to get into that. Obviously, if there are more witnesses who are going to be testifying about the same event, we don't necessarily have to hear everybody say that unless there's a dispute as to their credibility. And anybody else want to be heard as to the childhood experiences of Mrs. Menendez and the activities of her parents? All right, yes.
In terms of the, the remoteness of it, number one, there is evidence, obviously, that the father continued to be in the home long after they were officially separated.
Well, as I heard, there was some dispute with some interview witness the people had conducted.
I think not. I think the dispute was not as to his being in the home, but whether his behavior continued to be violent and assaultive. I think that the
Okay, he did.
representation
Yeah,
was that he did continue to be in the home.
he did visit without any. Well, we have the defendants and all counsel present. We have completed the in-camera hearing thus far. There are some other matters still to resolve, but getting back to the initial question of the patient-therapist privilege, which has been the subject of our discussion earlier this afternoon and this morning as well. The court has considered the argument presented by counsel as well as the briefs filed by both sides on this subject. I've also reviewed the case law that relates to this issue that has been cited by the parties. And I assume there is, at this point, nothing else to be said as far as counsel are concerned, since the matter has been fully argued. Okay. Did the people want to respond to that at all?
In the most limited sense, it's the defendant's mental condition at the time that they perceived correctly or incorrectly the danger to them. It's a very narrow interpretation. And again, just because it's not part of the DSM-3 doesn't mean that it's not a condition. So their condition is their perception of their parents, in the broadest sense, is the perception of their parents and their ability, well, everything that's covered under 1107, that's the type of emotional conditions which we contend has been put into issue. 1107, I mean, I didn't know 1107.
No, you said 1107.
Okay.
Well, Your Honor, we would contend that is not a mental or emotional condition. As that is defined by there would be no description of any such condition except they were afraid of their parents. So if what counsel's means is that the condition was fear of their parents as a mental state, mental condition, I can understand that, but I think now they're trying to broaden it into all of their perceptions of their parents. And I don't think anyone testified to what their condition vis-a-vis so broad a notion as perception of their parents was at that point in time.
You would also,
They certainly didn't. All they testified to was being afraid. And the experts testified to their being afraid and the history that they had, which gave them this special knowledge so that they had a reason to be afraid.
All right, let me say that in ruling on this matter, the court does not in any way derogate the general concept that has been outlined in the testimony that there is such a condition as battered person syndrome or battered woman syndrome, battered child syndrome. There clearly is such. It's accepted in the literature, accepted generally in the mental health profession, and it's further accepted in the evidence code as a concept that is one that the courts should not treat as a new or novel or unproven theory, but one that does occur. The issue in this case is when the defendants in this case specifically have tendered this evidence that we have heard throughout the trial, not just the evidence from their own testimony, but the entirety of the evidence, whether or not their mental condition has been put at issue, as set forth in section 1016 of the evidence code. And that section states that there is no privilege under this article as to a communication relevant to an issue concerning the mental or emotional condition of the patient if such issue has been tendered by the patient. And based on the evidence presented in this case, and specifically the expert testimony offered by the defendants relating to them specifically, their mental condition, how they reacted to specific instances and events that have been the subject of testimony, not just in their childhood, but events close to the time of the shooting of the parents. The court finds that in the context of this case, as the evidence has been presented, that the defendants have tendered their mental condition, their mental and emotional condition. This is clearly not a situation where a defendant testifies that there had been prior threats or prior acts of aggression by the victim, and those acts caused him to react a certain way. This goes well beyond that to the specific emotional and mental condition of the defendants that the defendants have sought to prove by way of the expert testimony. And by so doing, they have tendered their mental and emotional condition. The question has been asked as to what is that mental or emotional condition. It seems to me that that condition is one that reflects the psychological effects of physical, emotional, or sexual abuse on the defendant's ability to perceive fear in general or fear of the victims specifically. And communications relevant to that issue would seem to be communications that relate to their attitude towards their parents, any fear they expressed regarding their parents, their love or hatred of their parents, motivations in relationship to their parents, and any expressions or accounting of what transpired when the parents were killed. All of these things would certainly relate to their mental condition and would be relevant communications as to the issue of the mental condition that I've set forth here. And to that extent, the court finds the defendants have tendered that issue, and there is no patient-therapist privilege. That does not mean that every communication in their entire lives is open to this exception to the patient-therapist privilege. It, by its nature, relates to a time frame within a reasonable period of time of the actual killing of the parents, both before and after that event, which reflects on and is relevant to this condition. I can't give you a specific time frame, but certainly the time frame that is encompassed by the relationship of Dr. Oziel with the defendants would be included within that. It's hard to visualize how it would not, based upon the evidence presented here by the defense as to these events that occurred during that particular time frame. All right, so that is the court's ruling as far as 1016 of the evidence code. As far as the attorney-client privilege, and specifically the privilege relating to the December 11th tape-recorded conversation that occurred between the defendants and Dr. Oziel, that is a subject that the court will reduce to written findings and permit the parties to present further argument on that subject. I'll try to get it to counsel tomorrow so that we can finalize this issue. I've already posed a hypothetical, which I think pretty much relates to what occurred, and the people can research that if you choose to do so. And as far as other sessions other than the December 11th session, do the parties wish to pursue that matter now as far as the defendants presenting to the court their position as to what is irrelevant to the mental condition that the court has outlined, or do you wish to wait until we litigate and finalize the litigation regarding the December 11th tape recording, which it seems to me to be the most critical issue here that both sides are concerned with, whether or not that tape recording of the defendants talking to Oziel will be evidence that the prosecution can or cannot use.
My preference would be that we vote for that decision for a lot of reasons. Partly because Ms. Morris already said.
All right, what do the people want to do?
This is why we talk about it.
We can wait.
Okay, I would say that I'm going to do the best I can to resolve it tomorrow so that we can get it completed one way or another.
I do believe that I would expect you further in camera hearings, it may take a while.
I mean, in regards to sessions other than the tape recorded session.
Yes, on that specific issue of relevance, we may want some clarification from the court about the definition that the court just gave concerning how the court understands the particular mental state or emotional condition issue. That would help us in being able to tell the court whether there is or isn't relevant under that definition.
Well, what you should do then is present that to me in setting where the prosecution can hear your question so that we can then
Yes.
resolve it. So do you want to do that now or do you want to wait till tomorrow?
Let me think about what the court has said so I can ask some meaningful questions, particularly in view of the actual material.
Well, I would suggest the prosecution could do likewise if there is a clarification of the language that, as far as what the mental condition is and to the issues that relate to it. I think it's pretty clear what I've said as far as the type of evidence that would relate to that and would be relevant to that subject, whether there was expressions of fear or hatred
Right, that's obvious.
or discussion of why the killings occurred, things of that nature, certainly would relate to expression or the mental condition of fear, one way or another.
Yeah, I agree with all of that.
All right. Are there any other matters that you want to resolve before we hopefully continue tomorrow with a jury? We have both juries coming in, one jury at 9, the other at 11. We have witnesses scheduled. As I understand it, we pretty much have things lined up for those juries for tomorrow.
Yes, the only other issue that we need to resolve is the issue of the box and the letters, because depending upon what decisions are made there, either want to go into them with Dr. Counsel or not go into them with Dr. Counsel.
All right. Well, I'm unclear as to what you want the court to do. The court ruled in the defense favor in regards to the box and its contents, but with a clear indication that there was a potential of an instruction relating to that. Then there's been some discussions between you and the prosecution.
As I understand it now, and I don't know if I misstated, then please examine me correctly, but we indicated that we would turn over to the prosecution the letters and the box and its contents. She indicated she wanted to refuse to accept them and instead have the instruction that we were withholding evidence, because her point is that at the time that the request was made to take the box to Mr. Chayla, was an attempt to hide evidence at that time. I believe that's.
Okay, I think I can clarify. What was proposed to me is we'll give you the box and its contents if you withdraw your request for destruction of evidence during instruction. I said, let me think about it over the weekend. I thought about it. The two things are totally separate. My seeking an instruction on destruction of evidence or hiding evidence relates to what Lyle Menendez did on March the 8th of 1990, not that the attorneys are trying to hide it now. I mean, I think those are two separate things. I don't think a defendant can be held accountable for his attorney's actions. But what the defense is trying to do is to somehow ameliorate the fact that the jury has not been provided with this evidence. And I think those are two separate things. So I'm not going to agree to accept the box and its contents in exchange for giving up my right to either ask for an instruction or argue the events of Lyle Menendez requesting that these things be removed from his car. I think those are two separate things. Now, if the defense wants to come forward in front of the jury and say, look, we're turning over the contents, that's separate from me agreeing that in exchange for them doing that, I will give up the right to ask for this instruction, which relates not to their mental state, but the defendant's.
Well, that argument would seem to then turn on the content of the box. To fairly make that argument, the jury should be provided with everything in that box. And we would, to forestall that argument, would seek to introduce, as I understand it, they would object to the contents of the box and the letters going into evidence on hearsay grounds. But I don't think
Well, you can't have it both ways.
Yeah, I don't think they'd then be in a position to turn around and say we're attempting to suppress and destroy evidence.
All I'm saying is that people are not going to agree to accept this box now that we subpoenaed in December in exchange for giving up their right to ask for this instruction. That's where we are now.
You don't have to accept it. The defense could just offer it.
Right, that's right. But the negotiations with me were for that trade-off. And I'm just saying, I'm not going to make the trade-off. And then if they want to deal with it another way, then they're at liberty to do that.
All right, well, what did you want me to do, if anything?
Well, the issue is, they would object to the contents of the box, or the contents of the letters coming before the jury. And they want to make, which is, in some way damaging. And so we're saying we want to put all of that material before the jury, if that's the situation, so they can see that there's nothing in there worth hiding. There's a lot of extraneous material. The court's gone through it, and there's a lot of traffic information, various manuals and documents, and things like that.
I don't see a problem. If you want to offer the whole box, then it can be received and let the jury paw through it if they want. And you can make whatever you want out of it.
And that would include the letters, and this is Menendez's 4 letters, since the argument's going to be made that somehow there was an effort to hide material rather than to merely protect the memory to a degree by not putting forth suicide letters, etc. Then although they are technical hearsay, if we're going to be faced with the argument that there was an attempt to hide or destroy evidence, then it's our position and the jury has to see everything. It seems like kind of a silly way to do things, but that's where the negotiations broke
Okay.
down. And so it would be my intention to give Dr. Conti access to the box, ask him if he reviewed it, ask him if he read the letters and the impact of the contents of those materials on his opinion.
All right, I don't see the people are objecting to that. They were just objecting to themselves accepting it and agreeing to some sort of
Yeah, we were objecting to
drawings
this trade-off. I'd like to be able to, before it's admitted to the evidence, I'd like to be able to look at
Of course.
it. So I'm not gonna, if they wanna mark it and ask.
Well, why don't you, I thought you had seen it.
No, I haven't.
Okay, why don't you look at the contents and see what it is?
They
And-
wouldn't show it to me till I agreed to the procedure, and
Okay.
I didn't agree.
All right, now they want to offer it regardless, so why don't you look at that so that we don't have to waste time tomorrow?
Yes.
All right, anything else then?
Mr. Honor, there's also the issue of the business witnesses. We have culled down the number of business associates that we would seek to call to 2. I believe the prosecution had an objection to those.
Okay,
We need to resolve that.
okay, they gave me the reports of their interviews during the lunch hour or after lunch, I don't recall which. I haven't looked at them yet, but I'll read them tonight.
One of those witnesses is out of state, the other one is here.
Okay, well, which one is here?
The one that's here is Roger Smith, the one that's out of state is George Mills.
All right, I'll look at that. Anything else before we get started tomorrow morning? All right, let's see if we can get everybody here. So,
I'm not going to the first thing tomorrow morning, but I'm not going to be necessary.
right. But I want everybody here who's necessary for the Lyle Menendez jury so we can start at 9 o'clock. So please get here around 8:45 so that we can get started.